Ladies and gentlemen, a very warm welcome on a rather cold Saturday today to today's program, which is the first of its kind, which is the Legal Leadership Conclave organized by the India Legal Research Foundation on the topic of challenges, future and scope of arbitration and mediation. I request Mr. P.K. Malhotra and Mr. Indrajit Badhwar to escort our guest for the morning, Mr. Justice M.N. Venkatachaliah, onto the dais. Ladies and gentlemen, before we delve into the program chart, a few words about the organization that is conducting this program for us today. The India Legal Research Foundation is India's unique legal aid foundation which provides high-quality legal aid to those who are not able to afford it. It is part of the ENC media conglomerate which produces the India Legal magazine, which is India's first politico-legal publication. It is a one-of-a-kind journalistic endeavor focusing on current issues, consumer affairs, governance, law, and policy. ENC's broadcast arm is the path-breaking APN News and the N1 News, which are 24/7 national TV channels. These media outlets cover day-to-day court proceedings from all across India with an in-depth analysis by legal experts featuring judges, senior advocates, and luminaries. ILRF takes pride in promoting new ideas, initiatives, and recommendations for the benefit of not only the legal fraternity, but also the society at large. And one such initiative is the Legal Leadership Conclave. It's a series of interactive educational sessions which is being conducted across the nation in partnership with national law universities and the state legal services authorities. The first conclave was held in Mumbai in April 2019 on the topic of the new Insolvency and Bankruptcy Court. It was well attended and widely hailed for its grand success. The second is what we are here for today, on challenges, future and scope of arbitration and mediation. The aim of today's program is to bring about various stakeholders together and to evaluate how this particular field can have a turnaround and how it can be achieved. Talking about two inspiring persons who are behind this entire initiative, Ms. Rajshri and Mr. Indrajit Badhwar. Ms. Rajshri co-founded the EN Communication Private Limited and is currently the managing director. She has worked for over 19 years in the field of journalism and has gained vast experience in the Hindustan Times as a reporter in the NDTV, and then she also joined Sahara. She is perhaps the only mainstream television entrepreneur who has produced shows on development and specialized subjects like law, legal aid, and awareness for the rural masses. Her contribution to Indian journalism has earned her a number of honors and awards, and she is ranked among the top 50 personalities in India by the Indian Bar Association. Very inspiring indeed. And then, of course, we have Mr. Indrajit Badhwar. Mr. Indrajit Badhwar is the editor-in-chief of the magazine. We have with us the patron-in-chief of the India Legal Group, Justice M.N. Venkatachaliah, or Justice MNV as we fondly call him. We widely hail Sir as the Pitamaha of the Karnataka Bar and Bench. Justice MNV did his BSc and Law in Mysore University. Sir was appointed as the 25th Chief Justice of India in February 1993. Sir has also served as chairman of the National Human Rights Commission. Sir has headed the National Commission to Review the Constitution, and Sir has been awarded the Padma Vibhushan in 2004. And Sir has and is continuing to mentor a lot of legal luminaries and brilliant legal minds in the fraternity. Very, very, very honored, Sir, to have you with us today. The other inspiring person on the dais before us today is Mr. P.K. Malhotra. Mr. P.K. Malhotra has more than 40 years of experience in the field of law in various capacities. Sir has worked in the Ministry of Law and Justice for more than 25 years as an officer of the Indian Legal Service, and then Sir became Union Law Secretary. We now begin with the welcome address, and I request Mr. P.K. Malhotra to address the
It's my proud privilege to welcome you all to this legal leadership conclave on challenges and future of arbitration and mediation in India, being organized by the publishers of the magazine India Legal, jointly with the Indian Legal Research Foundation. The promoter group of this magazine, namely EN Communications Private Limited, is also running news channel APN, which is very popular among viewers in North India. Credit for taking this initiative goes to Mr. Pradeep Rai, Senior Advocate, and Mrs. Rajshri Rai, Managing Director of EN Communication. Talking about today's program, in order to emerge as a 5 trillion economy, it is imperative that we find ways to address the increasing judicial backlog, ease the burden on courts, and encourage investors' confidence. The need for reforms is essential in not only speeding up dispute resolution, but also having a strong in-country mechanism for out-of-court dispute resolution. Legally, this process, as all of us know, is practiced in the form of arbitration, conciliation, and mediation, and commonly we call it ADR. The process of ADR mechanism has become the newest cost-effective way of resolving disputes among parties. I'm sure we will have a very good interactive sessions during the course of the day, and will come out with some useful suggestions to make ADR mechanism more effective and fruitful. On behalf of the organizers of the Legal Leadership Conclave, I welcome you all. Thank you very much.
I now request Ms. Rajshri to present a token of our welcome to our guest, Justice M.N. Venkatachaliah. Right. Thank you, Ms. Rajshri. I now request the guests on the dais and off the dais to join us in lighting the lamp to inaugurate formally today's function. We now request our guest for the morning, Honorable Mr. Justice M.N. Venkatachaliah, to deliver the inaugural address.
Honorable Justice T.S. Thakur, Justice P.V. Shetty, Justice B.N. Sri Krishna, Justice Shivraj Patil, Justice Nagaratnam, Justice Aradhe, Justice Prabhakar Shastri, Justice Jagannath, Sri Ram Panchu, Sri Indrajit Badwar, Sri P.K. Malhotra, Mas Changappa, members of the Bar and the Judiciary, distinguished and respected invitees and participants, Ladies and gentlemen, I must thank Master Rajeshri Raj for trying to convince me that I am yet not totally useless. I was invited to address the Science Congress, Indian National Science Congress. In a weak moment, I agreed. Then I spoke on a topic which was a little intriguing. It was called the Ionian enchantment. And I had some difficulty in explaining my extraneous presence among scientists. Then suddenly it occurred to me that the Indian Science Congress itself was founded by Sir Ashutosh Mukherjee, a judge himself. So some of us who pretend to bear his legacy thought that we would justify being in the presence of scientists also. But in this task, I think I'm totally bowled out, because I have not done an arbitration, I have not done a mediation, and I don't know how I can justify my presence in the presence of Mr. Hiram Pancho, who is ladies and gentlemen, I'm conscious, deeply conscious of the honor of this invitation to me to inaugurate this conclave. Eminent men of law have assembled here to bestow serious thought on one of the most vexed issues of how traditional legal methods could be supplemented by more civilized and humane philosophy of conflict resolution in India. Justice, it is said, is the greatest interest of humans on earth, but the institutions of administration of justice and their methods, it's agreed on all sides, need a strong second look. Long ago, an English judge lamented that if Britain's business methods were as antiquated as its legal methods, it should have been a bankrupt country long ago. Law, it is said to be one generation behind the needs of time. The courts are 2 generations behind the needs of time, and the judges 3. Today, our civilization faces such disruptive technological explosions that all institutions, particularly the institutions of administration of justice, will flounder and appear funny like an old man wearing with attached fondness the clothes of his childhood. A.P. Herbert's misleading cases and more misleading cases tell us of the ludicrousness of the judicial predicament. The 20th century, writes Raymond Kurzweil, was not 100 years of progress at today's rate. 20th century was not 100 years at today's rate, but it's equivalent to about just 20 years compared to the 21st. Because we are speeding up to current rates of change. The 21st century will equal 2,000 years of progress at today's rate of progress. 1,000 times greater than what we witnessed in the 20th century. One of the tools of this change is, of course, artificial intelligence, coupled with deep learning and new technologies like blockchain, etc. The Homo sapiens, according to Anne Tattersall, the chief curator of the American Natural History Society, Homo sapiens is not simply an improved version of his ancestors, but a new concept itself, qualitatively distinct from them, a totally unprecedented entity. In short, everything will change. Humanity needs to adopt new ways of thinking if it is to survive. The 20th century was not itself a slouch for change. 20th century was significant for its spectacular progress in science. The controlled nuclear fission of the 40s, the human genome discovery by Watson and Crick 7 years later, research in the decade of the human brain and the Human Genome Project were all remarkable strides in the march of science. Some time ago, Time magazine had this lead article by Lev Grossman, which said that 2045 would be the year when men would become immortal. He refers to the work of Raymond Kurzweil, who believes that a moment will arise when computers will become intelligent, and not just intelligent, but more intelligent than human beings. What happens then? Our bodies, our minds, our civilization will be completely and irreversibly transformed. He believes that this moment is not only inevitable, but is imminent. Warner Ringe, in his the coming of technological singularity, predicts that we will develop the means to create superhuman intelligence. Shortly after that, human era of artificial organs will take over. Artificial intelligence implies robots, machine reasoning, neural networks, deep learning, and the vanishing presence of humans in the creative and the inventive pipeline due to the computational creativity of an extraordinary order. This raises several concerns for specialists of intellectual property law. A white paper was produced by a group of activists, researchers, and data experts who met at the Rockefeller Foundation in Bellagio Center to discuss the question of whether and how big data is becoming a resource for positive social change in low and middle income countries. Their working definition of big data included, but not limited to, resources such as social media, mobile phone use, digitally mediated transactions, the online new media, and the administrative records. They further said that big data might best be described as an analytical process, an approach to a question, or even a way of finding the best question rather than an object in itself. Big data terminology arose more than a decade ago from the corporate sphere, but needed some rethinking to fit it with the discussion on how this type of data might be useful to activists and civil society more generally. Seymour Papert, a scholar by name Seymour Papert, a mathematician, originally trained as a child psychologist, along with another scientist by name Jean Piaget, before moving to MIT, where he and Marvin Minsky co-founded the first artificial intelligence lab. Therefore, although the corporate world's definition of big data has remained fairly stable around the idea of 3 V's, namely volume, velocity, and variety, a broader perspective was adopted which includes the idea of datafication, the shift towards digital production and dissemination of information. The implication and this widespread provides crowd-sourced large statistical base. The implications and the widespread of this provide crowd-sourced large statistical base that can influence almost every dimension of our curiosities. Particularly poignant is the use of this technology in controlling and influencing the democratic process involving voter preference and voter behavior. Newer concepts of property and assets, hitherto unfamiliar to the legal terminology, will be the byproducts of the new technologies. This will bring newer ideas and concepts of power and privilege, which again in turn create newer assets and liabilities unfamiliar to the present commercial civilization. Newer concepts of intellectual property emerge. The traditional system will be unable to respond to the challenges of this fundamental change. The new technologies influence and control almost every economic activity around which the present world order revolves. The impact of the new disruptive technologies need a new category of judges whose specialized knowledge of technological domain becomes critical. The judge ceases to be the impartial umpire of the adversarial common law system, but the system will itself tend towards the inquisitorial. This will, in my opinion, make a marked shift from the accustomed norms of the adversarial system. The possibilities offered by artificial intelligence, says a source, come with significant risks. The prospect of those having the capability to devise the most potent algorithms to influence the decision of others. The threat to privacy or a person's own private opinions no longer remain private. What we should worry about more, says Noah Harari in his eminently readable book, 21 Lessons for the 21st Century, is the shift in authority from humans to algorithms. Shift in authority from humans to algorithms, which might destroy the remaining faith in the liberal story and open the way to the rise of digital dictatorship. But even as big data algorithms might extinguish liberty, they might simultaneously create the most unequal societies that ever existed. All wealth and power might be concentrated in the hands of a tiny elite, while most people will suffer not from exploitation, but from something far worse, irrelevance. The digital divide and the social consequences have been well documented. The world is no longer divided by ideology, said a scholar, but divided by technology. The new technologies usher in a new civilization, as it were. Everything will change. The combined effect of new technologies will compel all political, social, economic, administrative systems, including the medical sciences, to adopt and change. The judicial system will equally be transformed. But in the transformed situation, mediation will find the pride of place as a human tool to allay injustice and promote harmony. In the context of the great transformative changes, technology becomes the driving force behind all institutions, including administration of justice. In Professor Frank Sanders' words, dispute resolution mechanism should take advantage of a rich variety of different processes, which would singly or in combination provide for more effective conflict resolution. Mediation will assume the pride of place. Administration of justice through court systems has remained a source of reproach. There are about 34 million cases in the 22,600 subordinate courts in India. 10% of that, about 3.4 million, are in the high courts, about 60,000 in the Supreme Court. World Justice Report 2019, the Rule of Law Index, gave India 68th place among 126 nations. On the civil justice evaluation, they evaluated on 8 criteria. One of them was civil justice, another was criminal justice. In civil justice evaluation, India got the score of 97 out of 126, and the criminal justice evaluation, it got the score of 77 out of 126. It is no consolation that many of our neighbors, including China, are far below us in this scores. After the Lord Wolf report on civil justice system in England, there are striking improvements in Britain. In India, situation is possible. In India, a solution is possible if there is some authority which owns the problem. Unfortunately, nobody owns the problem of judicial predicament. Neither the Chief Justice owns it, nor the Prime Minister owns it, nor the Law Minister owns it. And it is at large, therefore, nobody is responsible for the solution. In India, a solution is possible if there is some authority which owns the problem. It's too serious a matter to be left alone to the judges. Those in authority must shed the traditional illusion. Those in authority must shed the traditional illusion of omniscience and seek help from systems experts. So far, solutions have become banal by reason of stereotyped speculation. Arbitration, mediation must become the new mantra for judicial salvation. Lawyers must become private sector judges before the case escalates to the public sector courts. There is today an eminent panel of great legal minds discussing these issues in this forum. We will benefit from listening to them at this conclave. I am honored to be invited to inaugurate this conclave, which I do with pleasure. I am grateful to Ms. Rajashri Rai of the APN for her gracious courtesy and invitation. Ladies and gentlemen, I just want to share a couple of thoughts on the kind of wisdom that we get by doing and being done. I think judges get a little more wisdom by being done. We have 22,600 subordinate courts in the country, statistically. Each court lists about 50 to 60 cases a day. decide half a case a day or one case a day. 60 litigants on one side, theoretically. 60 litigants on one side, 60 on the other side, 120, and under the 120 lawyers, there are 250 footfall in each court every day. There are witnesses also who come there. And all of them go back empty-handed. If you calculate the loss of man-hours and loss of productivity of the 300 and odd people coming to courts, 22,600 courts for 290 days. If you calculate the loss of man-hours at 250 rupees per head per day, it will be a whopping 2 lakh crores of rupees is a notional loss apart from the actuals. I think there's something that needs to be done and done very, very soon and quickly. Virtually, as I said, the system is like an old man wearing with attached fondness the clothes of his childhood and looks funny. And this conclave must convey a message how the new tools, the whole thing will change in another 5 years, whether like it or not. This artificial intelligence is not likely to be something like an experimental laboratory. It can influence every field of human activity, particularly the political behavior. And this is an elite group which will advise a political party which can overtake other parties by sheer exploitation of this data. And it is something which is not in anybody's control, as it were. It is only an elite which will control this. And it's also the finest ever for the judiciary. If they can use these new tools to, for example, there's predict that human lifespan is likely to be at least 200 years by the end of the century. They say with the present state of knowledge of human physiology, you can add 1 year to your lifespan every year. And the back of a used envelope, you can find out the arithmetic implications of the statement that you can add 1 year to your lifespan every year. And Kurzweil was asked, how do you do that? He gave you four solutions. You practice these 4 things, you add 1 year to your lifespan every year. And what are they? First is that you change your cooking oil into fish oil or olive oil. Second is change your white sugar into stevia sugar, extract from the stevin plant. The third is drink 9 cups of green tea. And the fourth is maintain the physiological alkalinity of the blood. Don't make blood acidic. And there is some water which is produced. In fact, they say some of the cure centers in Europe, the Islamic Zim water and the water, the Lourdes, they're all alkaline water. Now their equipment to sell alkalized water, not natural alkaline water, but they have Japanese are selling those machines at 300,000 people. 3,000 rupees. You pay 2.5 to 3 lakhs of rupees, they'll install a equipment which will supply you alkalized water. These are some of the things which are, and I don't know, our leaders are engaged in politics. I don't know where the leadership must come again from the judges and lawyers. If the lawyers make up their mind, the solution to the arrears will be absolutely simple. They can, there's a system which I wrote long ago. The judges of the Supreme Court in great wisdom said, increase the judge strength from 22,000 5 times. I was appalled. I thought, and I was overheard in thinking so, and somebody recorded it, that this is something like ordering new graveyards, opening new graveyards in anticipation of an epidemic. And somebody wrote it, that I said that I couldn't disown it. But I had to apologize to the judge who said, you increase the judge strength 5 times. Each court costs 1.5 crores per year. 22,000 is 30,000 crores. If you have 5 times that, it will be 1,50,000 crores more. You spend just 5% of it in this mediation, training mediators and arbitrators, and install these mechanisms of resolution in the alternative dispute resolution mechanisms. You can do that. But the point is, nobody owns the problem. The Chief Justice of India must own the problem. It is not delegated to somebody else. The Prime Minister must own the problem, or the Law Minister must own the problem. Now, all those who are helpless onlookers, they are now expected to solve this problem. And ladies and gentlemen, I am grateful to you for your patience and courtesy. I am really deeply sensible of the honor of speaking amidst such great judges. Thakur Sahab, Mr. Sri Krishna has done so much of work after retirement as he did in his term as a judge. Sri Ram Panchu is here, is a model of, he has spent all his precious time in trying to devise mechanisms which will rescue our situation from ignominy. Mr. Badwar is here, of course, as a powerful journalist. Journalists are more feared and perhaps also respected, some of them, and he is the most feared and respected. Mr. Malhotra was in the law ministry. I don't know what to say, that you have done me a great honor. I feel 5 years younger. I'm getting into my 91st year in a couple of months. And thank you, Rajeshri, for getting me. Thank you very, very much for your patience and courtesy.
Thank you, sir, for your words of wisdom and, of course, for sharing the 4 mantras for a long life.